9-0. That's not a narrow ruling or a disputed outcome. That's every single member of the Supreme Court, the progressive justices and the conservative justices, all 9 of them, concurring that multiple states across this nation have been infringing upon your constitutional protections. This judgment emerged from a legal battle the vast majority of Americans have never heard about, and it established a new precedent that applies to every state in the Union. Whether you currently possess a firearm, plan to acquire one, or simply value your ability to defend yourself, this ruling impacts you at this very moment. I'm going to break down precisely what happened, what the justices determined, and what you must understand before finding yourself in a predicament you never anticipated. Before I dive into the specifics of this case, let me pose a question. If the highest court in the land issues a unanimous verdict that fundamentally changes what you can legally possess for personal protection, wouldn't you want to know the instant it happens? Hit that subscribe button right now and click the bell so you never miss an update. Decisions like these continue to emerge, and those who learn about them first are the ones who remain protected. Don't find out after the fact that your constitutional protections have shifted. The case bears the name Catano v. Massachusetts. It reached the United States Supreme Court in 2016, and the final tally was 9-0. That level of consensus is extremely rare in Second Amendment jurisprudence. Most major firearms rulings end up 5-4 or 6-3. When every single justice arrives at the same conclusion, it sends an unmistakable signal to every court, every state government, and every law enforcement agency throughout the nation. This was not a contested decision. This was a constitutional landslide. Let me explain how this all began. A woman named H. Catano resided in Massachusetts and found herself in a perilous circumstance. She was trapped in an abusive relationship. She genuinely feared for her survival. She lacked the financial means to purchase a conventional firearm. An acquaintance gave her an electroshock weapon, so she could defend herself if the situation deteriorated. The complication was that Massachusetts had enacted legislation that imposed a complete prohibition on electroshock weapons, not a licensing requirement, not limitations on where you could transport it. An outright ban. Law enforcement discovered the device and she was taken into custody and formally accused of criminal activity merely for possessing it. Catano brought her case before the Massachusetts Supreme Judicial Court. That tribunal examined the situation and determined her conviction was completely legitimate. Their rationale was that electroshock weapons were not covered by the Second Amendment since they didn't exist in 1791 when the Second Amendment was drafted. They further argued that such devices weren't commonly utilized by civilians for self-defense. Therefore, they existed beyond constitutional protection. Hay refused to accept this as the final word. She appealed to the United States Supreme Court, and that's when the entire legal framework transformed completely. The Supreme Court overturned the Massachusetts ruling entirely, and did so with complete unanimity. The justices declared that the Second Amendment does not exclusively safeguard weapons that existed in 1791. The court stated that the Second Amendment encompasses all devices that qualify as portable weaponry, even those that had not been invented during the founding era. They also dismantled the lower court's reasoning regarding common usage, explaining that the way that particular standard was being implemented was fundamentally flawed. The state courts had reversed proper legal analysis, and the Supreme Court corrected them, all 9 of them in agreement. I want to stop here for a moment because I genuinely want to know your perspective on this. Should the Second Amendment protect every type of device a person might employ for self-defense, or do you believe certain limits should exist somewhere? Share your thoughts in the comments section immediately. I review every single response and I engage with them. And while you're there, give this video a thumbs up. This information needs to reach every firearm owner who has no idea this case ever happened. Now let me explain what this signifies for you individually. The court didn't simply rule on electroshock weapons. They established a legal framework, a precedent, and that precedent now applies in every state across the country. If a device can be carried on your person and utilized for self-COP protection, it falls within Second Amendment protection. That's the benchmark the court established, and it makes no difference whether you reside in Texas, California, Hawaii, or anywhere in between. That benchmark now represents the governing legal standard everywhere. Consider what various states were arguing before this ruling emerged. They claimed the founding generation only understood muskets and flintlock pistols back in the 1700s. So those are essentially the only items the Second Amendment can protect. Anything created after 1791 is completely open to prohibition. That argument no longer holds any weight. The Supreme Court eliminated it with a unanimous decision. That represents a monumental shift for every firearm owner and every law-abiding citizen who desires the ability to defend themselves using contemporary tools. Here's the first crucial concept you need to grasp. Back in 2008, the Supreme Court determined in a case called District of Columbia versus Heller that the Second Amendment safeguards weapons in common usage. That was a landmark determination. But certain states manipulated that language and employed it against gun owners. They would argue that a particular weapon isn't yet in common usage, so they could ban it before it ever gained widespread acceptance. The Catano ruling permanently closed that loophole. The court made absolutely clear that you cannot prohibit something simply because it hasn't achieved widespread adoption yet, particularly when people are actively employing it for self-protection. The second essential concept you need to understand involves state authority. States have historically enjoyed considerable latitude to experiment with firearms regulations. They've attempted to ban certain knives, electroshock weapons, tasers, and particular weapon configurations. Following Catano, any state that imposes a complete prohibition on an entire category of portable weaponry that people use for self-defense is occupying extremely unstable, could-be constitutional ground. Courts now possess a Supreme Court precedent they can invoke to invalidate such bans, and courts nationwide have already begun applying it. The third essential concept involves technological advancement. The Second Amendment was drafted more than 2 centuries ago. Technology has progressed in ways the founding generation could never have anticipated. People don't defend their homes with muskets anymore. The court declared unequivocally that the Second Amendment must adapt to the modern world. A weapon that exists today and is employed for lawful self-defense deserves constitutional protection, regardless of whether any founding father ever held one. That principle extends far beyond just electroshock weapons. The fourth critical point concerns your baseline protection, regardless of your location. Before this ruling, your constitutional rights could diminish dramatically the moment you crossed a state boundary. Something you legally possessed at home could become criminal activity in the neighboring state. Catano doesn't eliminate every state regulation, but it establishes a foundation, a minimum level of protection beneath which no state can fall. If a weapon qualifies as portable armament used for self-defense, you possess a constitutional right to it, and states must honor that right. Period. Here's something I want you to contemplate for a moment. Which state do you predict will be the first to have a major weapons ban invalidated as a result of this ruling? I have my own theory, and I'm curious whether yours matches mine. Put it in the comments and I'll share my thoughts. And if you haven't subscribed yet, now is the perfect moment to do it. Legal challenges built directly on this precedent are advancing through the court system at this very moment. Subscribe so you'll be notified when those decisions arrive. Here's what most people completely fail to understand about Caetano. The case itself dates from 2016, but the narrative didn't conclude in 2016 and it continues to develop. Courts throughout the nation have been referencing this ruling in cases involving magazine capacity restrictions, knife regulations, electrical devices, and other unconventional firearms. The groundwork the Supreme Court laid in 2016 is actively being expanded upon today. This is an ancient history. It's an ongoing legal transformation happening right now. Let's examine what's been occurring in state legislatures. Certain states have quietly begun reviewing their weapons regulations since this ruling emerged, because they recognize that broad prohibitions are now constitutionally vulnerable. States, including California, New Jersey and Massachusetts, maintain some of the most restrictive weapons laws anywhere in the country. Legal challenges to those regulations have already been filed that specifically cite Caetano. Some of those challenges have already succeeded. The ones that haven't yet prevailed continue moving through the courts at this moment. Consider what happens when a case built on Caetano reaches the Supreme Court again. The justices delivered a clear message in 2016. Then in 2022 they delivered another, in a case called New York State Rifle and Pistol Association versus Bruin. That was a 6-3 ruling stating that gun regulations must be grounded in historical tradition. From the founding era, when you combine Bruin with Caetano, you obtain a two-part legal test that renders many modern weapons restrictions nearly impossible to defend in federal court. The legal momentum is shifting faster than most people recognize. The ATF, which stands for the Bureau of Alcohol, Tobacco, Firearms and Explosives, has also experienced the effects of this ruling. The ATF has attempted to regulate certain weapons and accessories through administrative directives, meaning regulations they create independently without congressional approval, when the Supreme Court declares that the Second Amendment covers all portable armament. That restricts the ATF's authority to prohibit or restrict items unilaterally. Regulations that might have gone unchallenged before Caetano are now being contested in court using precisely this argument. Second Amendment attorneys are actively pursuing those cases. Here's something most firearms channels aren't discussing at all. The Caetano ruling also carries significant implications for individuals with prior convictions who are attempting to navigate their rights. Courts are being asked right now to apply the Caetano standard to situations where someone's rights were restricted or partially restored. The constitutional question being raised is straightforward. Does this individual possess a right to own a portable weapon for self-defense? That question doesn't have a uniform answer across every circuit yet. It's actively being litigated in federal courts as you watch this video. Now let me guide you through 3 realistic scenarios where this ruling could directly affect your life. These aren't abstract examples from a legal textbook. These are situations that happen to ordinary people on regular days. Imagine the first scenario. You're driving home at night and you're pulled over for a defective tail light. The officer notices a taser sitting in your center console. In certain states before Caetano, that officer could have arrested you and charged you with a crime merely for possessing it. After Caetano, a state law that completely prohibits possession of a taser is constitutionally questionable and susceptible to being invalidated. Now here's the crucial distinction. Even if the law is unconstitutional, it may still remain on the books in your state today. You could still be arrested. The way this works in your favor is after the arrest in court with an attorney who understands how to employ this ruling as a defense strategy. The moment of the traffic stop is not the appropriate time to debate constitutional law with law enforcement. Remain composed, be respectful, and challenge it, legally afterward. Imagine the second scenario. You want to protect yourself, but for some reason, owning a traditional firearm presents complications at this moment. Perhaps there's a legal issue in your background. Perhaps you're in a financial situation where a firearm isn't affordable. The question becomes, what can you legally employ for self-defense? Catano directly addresses this. The Second Amendment protects non-firearm weapons that are used for self-defense. If your state completely bans electroshock weapons or tasers, that prohibition is potentially unconstitutional under this ruling. That doesn't mean you should purchase one tomorrow if it's currently illegal in your state. It means there's now a legal avenue to challenge that ban that didn't genuinely exist before 2016. Consult with a local attorney before taking any action. Imagine the third scenario. You reside in a state with restrictive regulations and you want to have something in your home to safeguard your family. Certain states have attempted to extend their prohibitions inside the home. Arguing specific weapons are too dangerous even for residential defense. Following Catano and following Heller, that argument is extremely difficult to maintain. The Supreme Court has been absolutely consistent on one point. Law-abiding citizens possess a constitutional right to keep arms in their residences for self-defense. If your state has a law that bans a category of non-lethal or less lethal weapon, even inside your own home, that law is legally vulnerable, and it's worthwhile having a conversation with a Second Amendment attorney about challenging it. The pattern in all three of these scenarios is identical. Catano doesn't give you permission to disregard laws that currently exist. What it provides is a constitutional weapon your attorney can deploy when those laws overreach. Understand your rights, document everything, remain calm during any interaction with law enforcement, and then allow the legal system to work in your favor afterward. Now, let's address the misconceptions because considerable misinformation exists about what this ruling actually accomplishes, and incorrect information about your rights is just as dangerous as not knowing them at all. The first misconception is that this ruling only applies to electroshock weapons. This is completely inaccurate. Yes, the case originated with an electroshock weapon because that's what H. Catano possessed. But the principle the court announced wasn't limited to electroshock weapons. The court declared that the Second Amendment extends to all instruments that constitute portable armament, all of them. Electroshock weapons were the illustration. The rule is far broader. Courts nationwide are already applying it to other weapons. It's not simply about electroshock weapons. Don't allow anyone online to convince you otherwise. The second misconception is that you can use this ruling to carry anything you want, anywhere you want. This is false, and acting on it could result in serious consequences. The ruling doesn't dismantle every weapons regulation in existence. States can still regulate who carries, where they carry, how they carry, and what training or licensing is required. Catano builds on the 2008 Heller decision, and Heller itself stated explicitly that certain regulations are constitutional. Think of Catano as elevating the baseline of your rights. The baseline can't be lower than constitutional protection for portable armament, but there remains a ceiling of reasonable regulation above you, and states can operate within that space. The third misconception is the most dangerous one. The misconception is that this ruling is outdated and no longer matters because it happened in 2016. People who claim this are causing genuine harm by making gun owners disregard something that's still actively shaping the law. Courts are citing Caetano right now. Attorneys are filing legal arguments right now that build on what the Supreme Court said in 2016. Combined with Bruin from 2022, this ruling is part of an expanding legal movement that's reshaping Second Amendment law in real time. Caetano is not outdated. It's the foundation, and foundations don't deteriorate. Remember what I told you at the beginning, 9200, every single justice. That level of consensus sends a signal to every lower court in the nation. When you combine that unanimous signal with the 2022 Bruin ruling, you obtain a federal judiciary that's being compelled more and more to apply genuine scrutiny to weapons bans. The impact of Caetano isn't diminishing over time. It's expanding, and the people who comprehend it are the ones who understand how to respond when their rights are violated. Let's bring everything together, because these are the three things you absolutely need to take away from this video. The first one is this. The Supreme Court ruled 9-0 that the Second Amendment protects all portable armament, not just the weapons that existed when the Second Amendment was written in 1791. Modern weapons, non-lethal weapons, and even weapons that haven't been invented yet all have potential for constitutional protection if they're employed for lawful self-defense. No state can look at something you own for protection and claim the Constitution doesn't apply simply because it's new. The court eliminated that argument, and every single justice agreed to eliminate it. That's your constitutional protection, and you need to know it exists. The second one is this. Your rights depend significantly on where you live right now, but this ruling establishes a constitutional baseline that no state can fall below. States can regulate, they can require permits, they can restrict where and how you carry, but they cannot impose a complete ban on an entire category of weapon that people use for self-defense without facing serious and likely successful legal challenges. This ruling gives your attorney a genuine tool to use in court on your behalf. Know that it exists, and if you ever find yourself in a situation where a law is being used against you that goes too far, this is one of the instruments that can help you resist. The third one is this. Caetano remains relevant, and it's gaining strength. It's being used in courts today. It's being cited in legal arguments filed this week. It's being combined with the Bruin decision from 2022 to construct a legal case against excessively restrictive weapons laws across the country. You're living through a crucial period in the history of the Second Amendment. The more you understand about decisions like this one, the more capability you have to protect yourself and your family when it matters most. Consider the broader context for a moment. Every generation must struggle to preserve the rights the Constitution guarantees. The Supreme Court doesn't always reach the correct conclusion from a gun rights perspective. Sometimes it's a close decision that goes the wrong direction. But when all 9 justices arrive at the same conclusion, that represents a significant moment. That's the court establishing a boundary and declaring this far and no further. The boundary they established in Caetano declares that the right to keep and bear arms is not a museum piece frozen in 1791. It's an act of right that applies to the world you actually inhabit, and it applies to you. You bear responsibility for understanding these rulings. Not to win arguments online, not to impress people at the shooting range, but because comprehending your rights forms the basis of being able to defend them when someone attempts to remove them. Knowledge represents the first level of protection. It precedes any weapon you could ever possess. Don't delegate your understanding of your own constitutional rights to someone else. Own it, learn it, carry it with you. H. Caetano was a woman living in fear who simply wanted to be safe. She couldn't afford a firearm. A friend provided her with an electroshock weapon. Massachusetts declared she had no right to possess it, and 9 Supreme Court justices informed Massachusetts that it was wrong. That ruling didn't just protect her, it protected you. It expanded your constitutional rights in a way that reverberates in courtrooms and legislatures throughout this country at this very moment. That's not insignificant. That's the system functioning as it should, and that's a story every gun owner needs to understand. If you've made it this far, you're exactly the type of person this channel exists for. Subscribe right now and enable all notifications. Legal developments are emerging constantly and you need to remain ahead of them. Leave a comment below and tell me which aspect of this ruling surprised you most. I'll be reading every single response and I want to hear your perspective.